Over the AI Rainbow, it's Entertainment Law Update, episode 166 for March 2024. Hello, welcome to Entertainment Law Update from Los Angeles, California. I am Gordon Firemark.
And from the Dallas-Fort Worth Metroplex, I'm Tamara Bennett.
And we thank you so much for joining us again for another episode. This is our podcast about entertainment law, where each month we pull together a roundup of legal and business news stories and share our opinions and commentary and analysis and enjoy each other's company a little bit. So, Tamara, what's new with you?
I think last time we spoke, I was headed to New Zealand, or had I already come home?
You had already come home, and you shared all the excitement about that. So
there you go. So it's been a blur of catching up since last we spoke. I think I had just gotten home. It's hard to believe. Yeah. So that's about all that's new with me is just work with work.
Yeah, and it's been a sort of quiet month around here for our family as well, and for work too, which is not always the best thing, but you know, it comes and goes. So nothing big to report here. I'm getting ready next week to speak at the Podcast Movement Evolutions Conference here in LA, and then going off on a little family trip out to the desert for a few days just to spend a little time with family, and well, some of the family, because some of us have other obligations, and my wife and daughter are both going to be scattered to the winds while the boys and I go enjoy family time.
Yeah.
Well, I mean, my mom and her husband and my sisters and their families will be with us. But anyway, it's going to be great. So looking forward to that. And then back to it after spring break, and off we go.
Yeah, so you guys, I guess your kids are out closer to the Easter holiday for spring break then.
Yeah, our trip next week is actually the week before their official spring break from school, but it's when we could get the timeshares and everything arranged. So
thank you. Yeah, so I think our son is making a quasi surprise visit for his spring break. So from
not much of a surprise if you know about it, but
it's not. But surprising some other folks.
Oh, okay.
Yeah, cool. Well, no, he's in on it, but surprise my mom, I think.
Nice. Okay,
so that'll be nice. Yeah.
All right. Well, let's take care of some business, and then we'll get to the subject matter of the show. First off, we'll let you know that this episode of Entertainment Law Update is sponsored by JD Supra, a leading platform in professional services content marketing, helping lawyers turn their expertise into networking opportunities, media visibility, and new business. JD Supra publishes and distributes blog posts, articles, podcasts, including our podcast, videos, and other thought leadership to hundreds of thousands of subscribers each day. And that includes business leaders, in-house counsel, media members, the C-suite, and others who have a need-to-know interest in legal, regulatory, and compliance matters. JD Supra clients not only enjoy wide readership of their thought leadership, they are also provided with the data and tools to turn visibility into marketing and business development success. You can find out more about JD Supra by going to resources.jdsupra.com. And we thought we'd start off the show with not exactly a legal story, but an entertaining and interesting story about the very famous song Over the Rainbow. A March 6th article in the Hollywood Reporter has this fascinating story that we just wanted to share with you, and I think it's worth the read. But we'll give you the short version right now. The Academy Award-winning ballad Over the Rainbow, from The Wizard of Oz, of course, is perhaps one of the most enduring melodies ever to come out of Hollywood, but it has an uncanny similarity to a long-forgotten piece by a Nazi-era composer, and that has some people questioning the authorship of the song. So what happened is this Norwegian pianist Rune Alver happened upon some sheet music written in 1910 in the U.S. by a composer named Signe Lund, who was traveling around the U.S. performing. She was very, very popular at the time. The song was called Concert Etude Opus 38, and it was written in 1910. And she performed this in a number of American cities. It was one of the most popular pieces in her repertoire during her lifetime, according to this Alver fellow. So the similarities between that song, Opus 38, and composer Hal Arlen and Yip Harburg's Over the Rainbow are kind of hard to miss. And so the article in the Hollywood Reporter goes into some depth on the background and the similarities and the differences between the songs. And it's a very interesting piece about American film music history and music generally. And but the big question on everybody's mind is, hey, was that song plagiarized back in the day? And then, of course, it came just before World War II, when a European composer might have had a pretty hard time dealing with being a plaintiff in an American court and those kinds of things. So nothing ever came of it, and here we are, what is it, about 90 years later, with nobody's left around who knows all the details from personal
Right.
experience. So it's not going to be a lawsuit, but it's an interesting
Yeah.
story nonetheless.
Yeah. No claims that I don't think can be brought or arise from that. And it was,
There's a
she
statute of
composed in
limitations.
statute of limitations, 1910. Her work as well would be public domain.
1938. Yeah, right. So
Yeah.
1938 was when The Wizard of Oz came out, and anyway, a little bit of history. It's always fun to read. But plagiarism is in the headlines now, also relating to a film. The Academy Award nominated Holdovers has been accused of being plagiarized. Alexander Payne's Oscar-nominated film, The Holdovers, is caught in this contentious dispute with the writer of the film Luca, Simon Stevenson. I should say Luca is one of his most famous films. Stevenson has accused the drama and Payne of being a line-by-line copy of the unproduced screenplay Frisco, and that has led to a lot of controversy during the awards season and so on. The scripts share similar premises, focusing on a world-weary middle-aged man, a couple of world-weary middle-aged men, and a 15-year-old under their care, but there's different contexts. So it's really captivated the attention of the public and the community, and some think that the evidence is damning, and others say no, little in common other than some structural similarity. But it is what it is. And so the Writers Guild has been brought in to look at the dispute. Nothing has yet happened, but Stevenson is considering legal action against Payne and the producers of The Holdovers. And so if that comes to pass, we will keep you posted.
Yeah, so he's alleged similarity, but he's also alleged access. So there may have been some shopping or passing of things around in 2013 and 2019. So it'll be interesting to see where that goes. I have to tell you, I loved The Holdovers.
Yeah, I haven't seen it yet, but I'm.
I encourage everyone to watch it. It was really, really. It did not disappoint. It was really good. Yeah.
Well, good. Well, in our last episode 165, we talked about the Eighth Circuit upholding a district court ruling over that sort of guest sheet intake form and the blank form doctrine. I remember we joked about the name of the plaintiff in that case was Ronald Reagan, Ragan, and he was suing Berkshire Hathaway Automotive over their use of a very similar or identical form. And the court in that case held that it was a simple document, basic questions, prompts, and checkboxes with fewer than 100 words altogether. And so it was a tool for collecting information, and didn't really have the requisite level of creativity. But we have a new case. You want to take this one?
Yeah, and maybe what makes the difference here is there's more than 100 words, but I don't think that's what the court brought out.
Are we drawing a line? Is it 123?
No, that's kind of like if it's anyway on how much you can change to be protected. But this is the Sixth Circuit, a different decision, and this was a document that looks a whole lot like just a lot of terms and conditions that we might receive in any contract we enter into. But it was a loyalty certificate for a lifetime powertrain loyalty program by automobile dealers aftermarket products. So it's Premier Dealer Services versus Allegiance Administrators, Sixth Circuit 2024. The Premier Dealer Services, a developer administrator of automobile dealers aftermarket products, sued Allegiance Administrators for infringing its copyright in this document. That is the loyalty program, and it goes through what each person who would buy this loyalty program, what they would receive in exchange, um, to repair defects in the car's engine, so on and so forth. 2-page document provided to, if I was the car owner and I purchased it, I would get this certificate, and these terms and conditions were on there. And amazingly enough, the plaintiff in this case actually filed a copyright application and received a registration for this document. And Premier argued, and the court said, originality in a copyright only requires the author to independently create a work with minimal, modest degree of creativity. And the court concluded that the certificate had that enough original expression for protection. The court said the customized expression and organization of which places the certificates beyond the kinds of highly abstract descriptions typically of uncopyrightable facts and ideas. So it did talk about the Feist and rural telephone case, saying it was more than just organizing of facts and ideas. Different categories of maintenance were included that had to be expressed. I'm still going, Anyway, defendant argues that there should be an exception going kind of to what we talk about often in these film and TV cases of scenes affair.
Yeah.
That there's only so many ways for an author to express facts, and how many different ways can you express the facts of how we're going to repair your automobile, and that there just was minimal creativity. But the court disagreed and actually made them disgorge defendants disgorge their profits. Can you believe that? It noted that Premier had successfully shown a reasonable relationship between Allegiance's infringement and its gross revenues, and withheld an award of attorney's fees, finding the lower court did not abuse its discretion in characterizing Allegiance arguments as unreasonable and contrary to settled law.
Wow.
Bum, bum, bum. What do you think? I mean, and we've attached the complaint. I'm sorry, we've attached the opinion, and the exhibit to the opinion includes the certificate that's registered for copyright. So folks can go take a look at that.
Well, is this a split of authority now, or do we have enough distinguishing factors that we don't expect? I mean, not that I really expect the Supreme Court to rule on a case like this anyway, at least not the current court. But is it a split of authority, or is there enough difference, do you think?
I don't know. I mean, I made some notes to myself. I'm like, well, maybe I've very creatively written a contract, and I don't want people,
That's
other
exactly what
lawyers,
I was thinking. Is my contract language something that's minimally creative that can be I mean, I suppose there's always a line to be drawn, but this, I don't know which one I like better.
And I don't know, for the fact that attorney's fees were awarded, or there were some facts there as far as the person being a prior either employee or independent contractor, or there was a relationship, and then they took the document and started using it at a competitor. To me, this sounds in unfair competition, but I guess how nice for them that, for the plaintiff, that it was.
So maybe the distinction is the facts in the case rather than the yeah. So okay.
It raised some issues with me. I mean, I'm not going to probably start copywriting my contracts, but
the real question is, for those of us that are in neither the Eighth nor the Fifth Circuit, what do we tell our clients when they come and ask us about these kinds of things? Is it Fifth or Sixth?
I think it was Sixth. We've got another case we're going to talk about out of the Fifth Circuit. But or do we say, hey, do you want to spend this money to file a copyright application and see what happens?
Yeah. Well, what do? You register the copyright at least, and hope nobody infringes, and you never have to test it in court, or you don't have to until it's more settled law, I guess. I don't know.
Right. And I think, I still argue that today, I think these copyright applications would be denied for minimal originality.
Yeah.
But it could be wrong. Could be wrong.
Yeah, and it stands up fair, but also that sort of useful article. A contract or a form like this really serves a functional purpose. That, as the other court said, gathering the information. It's not about communicating information; it's about gathering it, so that
Well, but I think maybe that's the distinction,
maybe,
Gordon,
yeah.
is that this document communicated
Oh, good
information.
point. Yeah,
So
yeah.
it communicated if X happened, you could expect Y.
It was a customer-facing document
That's
versus
right.
the
It wasn't
dealer-facing. Yeah,
internal. So it did express what I could anticipate if
yeah,
if I was the consumer
sure.
purchasing this product. But I do think of many form documents I've drafted for clients that were
Mm,
customer facing where, if you could choose between A, B, and C on the services. And if you
right.
picked B, then you got 1, 2, and 3. So I mean there were options and I'm thinking,
The words
how many
Chinese
different
food menu
ways?
just came.
Yeah, yeah. Number 23. So,
Exactly.
and if they had pictures,
Yeah.
could be copyrightable
Good
expression
point.
on that Chinese menu.
Definitely.
So,
Yeah, there's another scenario. Anyway.
right.
Well, that's really, interesting, and something I guess we keep watching and see what other circuits do. It's sort of surprising to see two of these happen within months of each other like this. So, I suspect it'll be a while before we see another form
Yeah,
or
and
template
if
case.
if folks have cases they can talk about
Yeah, let us know.
related to this, let us know because we're really interested in how this is playing out.
Yeah.
Or if you've had cases where you've had something denied recently for not being sufficient originality, that's a quote form document,
Hmm.
and that's public record. Let us know.
Yeah. Well, let's move on. Let's go on over into our AI corner. We have a handful of stories in here this time around. We've been covering the stories about copyright infringement claims against the AI companies, the authors' class action for using their published works, the journalists' claims of violation of their rights, and last month we covered the story of Sarah Silverman's case and their setbacks and loss of a number of their claims and so on. But there are two nearly identical lawsuits that have been filed now by the same firm, one for The Intercept and the other for Raw Story and Alternet. They are going a slightly different route. They're looking at the copyright management tools that are, in their content. So these are both in New York federal court. At the end of February, they were filed. They accuse the AI companies of taking steps to conceal copyright infringement by removing certain information, the authors and the titles of the articles. They claim that OpenAI and Microsoft knew that ChatGPT would be less popular and would generate less revenue if users believed that the tool was violating copyrights, and that could lead to liability for distributing responses that the tools generated. So, according to the complaints, ChatGPT provides responses to users that regurgitate significant amounts of material from copyrighted protected works without providing information relating to that author, title, terms of use, and so on. And if the user asks the chatbot about a current event, for example, it provides answers that mimic articles covering
Mm.
those events from those media. So this is quote, this is at least because the defendants were aware that they derive revenue from user subscriptions, that at least some likely users of ChatGPT respect the copyrights of others or fear liability for copyright infringement, and that such users would not pay to use a product that might result in copyright liability or did not respect the copyrights of others. So tricky stuff. The suits are coming off the heels of a shift of how AI does its thing. And just last year, they decided no longer to disclose the source material that they used to train this thing and so on. So this is really a DMCA removal of copyright management information kinds of claim. And Intercept's claim says OpenAI uses its articles as source materials, but it stops short of claiming infringement. They're really focusing on that removal of information. So the
Hey,
DMCA, go ahead.
well, I was going to say this doesn't surprise me because I think
Mm-hmm.
the content owners are going to try every route
Of
possible
course. Yeah.
to stop this. But the argument that someone would be less likely to infringe if they were aware that it's more likely they are infringing.
Right.
I wish. But
Right. Well, I mean, I
that's well,
guess.
I guess that's along the lines of, well, it's on the internet, so I can use it.
Mm-hmm. Mm-hmm.
It must be free for me to use if it's on the internet. I mean, well,
Yeah.
so, but maybe if it's on the internet and but that's, I think, the portion of the DMCA about removing that copyright management information is to put people on notice.
Mm-hmm.
And if I were to use something and it has copyright management information on there, I can't be an innocent infringer.
Right. Yeah. The
So
handful of
if it's
conscientious users.
removed, if it's removed, then I could potentially argue, but
Yeah.
I was innocent. There was no copyright management information.
Yeah. Well, what's interesting is DMCA actually carries a $2,500 statutory damages for this kind of violation for each instance of a removal of copyright management information. So if the companies are found liable, that could really add up, considering the vastness of the catalog of stuff that's been ingested by these tools to train the systems. So,
But then how would they being the AI tools,
mhm.
spit out the copyright management information? I mean, when they spit it out, they're going to attach a source to it?
Well, I mean, we expect college students to put footnotes in and lawyers
Yes.
to put citations, right? I mean, I suppose it's possible to, the whole point of these AI tools is that they're not just spitting out a quote, but they're interpreting a lot of information and giving a new, if not original, sentence or statement, right? So yeah, it's an interesting question. How would you do it? Could
Yeah.
you design the tool so that if you click on a particular sentence, it gives you the sources that were used for that? Who knows?
Right. You've got a little virtual footnote up there. You can click
Yeah,
it and say, "Oh, yeah, this goes to that source," and then I can verify the information.
technology tools could do. It may require technology tools to do it. If this becomes a point of liability for the AI, they'll figure
And
out a
then
way.
doesn't that make it great for the college student who had AI write their whole report, because then they've got all their citations.
Well, it's interesting.
Anyway.
I teach a couple of college classes, and a couple of weeks ago, I had an assignment with students. They had to turn in some written work, and after they turned it in, I said, "Hey, did anybody use AI to help write this?" And none of the hands went up. And I said, "Well, first off, I don't believe you, and secondly, why not?" Because I think it's a really important tool. You can use it effectively, and I would have been okay with it. And I then later found out that some of the other professors at the same school take a completely opposite position. Absolutely not. That's cheating. Don't do it.
No, yeah. So
So this is
I talked to a
academia.
law student, right, in the last year, who they actually, as one of their research projects, the professor asked them to use AI,
Sure.
because I think they wanted to do kind of a compare and contrast, and help them use that tool and see.
Yeah. I mean, I
And
think,
as we pointed out many times, in the legal front, it's often wrong.
well,
So
and that's absolutely, that's the risk. But I really
yeah,
think in the academic environment and the nature of pedagogy nowadays, this asking students not to use these tools is a little like asking a photography student not to use Photoshop, or
mm,
uh, these are the tools that they're going to have at their disposal when they're out in the real world, and we need, as educators, to be training them, or at least allowing them to use the available tools within reason, obviously. So anyway,
yeah.
enough about the theory of teaching. But another AI story: NVIDIA, the chip maker, whom they've been making the graphics chips and graphic processing devices for a number of years now. I heard an article on the news the other day. They apparently invested in the AI very, very early on, 10, 12 years ago. They started sort of pointing their nose in that direction. And they are now facing a lawsuit from a group of authors who say that NVIDIA used their copyrighted works without permission to train its platform, NEEMO.
Mm,
So Brian Keene, Abdi Nazemian, and Stuart Onan said that their works were included in a data set of 196,640 books that were used to train NEEMO to simulate ordinary written language, before it was removed in October due to reported copyright infringement.
Oh,
So,
wow.
yeah, the author's proposed class action lawsuit was filed just a couple of weeks ago now, in San Francisco federal court, and claims that NVIDIA admitted it trained NEEMO on the data set and and therefore infringed copyright. So that's a brand new case. We'll be seeing more about that one, I'm sure. Interesting, though, that if it was used to simulate ordinary written language, then I guess we're talking about the ingestion side of infringement, which we've already seen a number of courts sort of throwing that out and saying, it's. I think we talked about maybe it's covered by some of those transient recording, ephemeral recording kinds of into software kinds of things. So we'll see. We'll see.
I wonder what would happen if they ingested a powertrain engine.
Limited warranty.
Limited warranty.
Or certificate, yeah.
Sorry.
Tell ChatGPT, give me a certificate of warranty.
Oh, yeah. Let's just see what that happens.
Yeah. And
It's
I
going
think
to
that would
suddenly
support.
be, yeah. Well, I'm sure ChatGPT probably, if we had it trained and we were saying that, it could probably spit that out for us while we're.
And then I wonder if that would support the argument that this is sans affaire. There's only a few ways to say these things. Who knows? The machine did it. So.
If only I had time to do that, I would be all over it. So,
well, some AI computer technology and law student will jump into that, I'm sure.
Yeah. One of our loyal listeners, you guys jump in and do that for us and send it to us for the next episode, and there will be a shout out available. So, our next topic, you had me at Roadhouse.
Yeah. Have you seen the new Roadhouse movie?
No.
Okay, nor have I.
And is this what it's based on? What we're going to talk about?
So, the original Roadhouse was the film starring Patrick Swayze and,
Sam Elliott.
And Sam Elliott and Laura Dern. And anyway, it was an enjoyable movie. The original screenwriter of that, go ahead, you can do the story. It's the original screenwriter.
The original screenwriter one, I guess, I don't know, maybe we're dating ourselves again, but I love me some Roadhouse. So anyway, Lance Hill was the original screenwriter of Roadhouse. And I was about to say remember what year Roadhouse actually released the movie. Anyway, he's initiated a lawsuit against Amazon Studios and MGM in California, citing copyright infringement. Hill asserts that he reclaimed the rights to his 1986 screenplay, so obviously sometime after that, and accuses the studio of proceeding with remaking without securing a license from him, and he's seeking a court order to halt this movie's release. So the allegations being that the screenwriter filed a copyright grant termination to reclaim his rights, and that he would have reclaimed those rights in 2021 in the U.S. for purposes of this termination. But in the interim, these allegations are being made that Amazon was trying to remake this film during the writer's strike. They then used AI to replicate actors' voices. And in addition to this copyright grant termination claim he's got going, there's a claim that it's violated the collective bargaining agreements with SAG-AFTRA and the Directors Guild because of this use of AI. Of course, Amazon and MGM are saying this should be dismissed. It's baseless, emphasizing that no AI was used to substitute actors' voices. So we've got this AI issue going on, plus we've got his copyright grant termination claim going on, and whether or not the screenplay that he wrote was classified as a work made for hire, which under Section 17 U.S.C. 203 and all of the surrounding sections of the Copyright Act, if it was a work for hire, then he's unable to effectively terminate this grant and reclaim the rights. There was also some concern over this being released exclusively on streaming platforms. And again, it does underscore this claim between content creators and trying to reclaim their rights. And we talked about it in 2022 when Paramount was also sued over Top Gun by the heirs of the author of the 1983 California magazine story, upon which the Top Gun first movie was originally based on. And that case is still pending. It's Yanni versus Paramount Pictures, and according to Pacer, the parties have tried mediation, and it's set to go to trial sometime later this year. And I'm just putting in a practice pointer. So if you represent clients, or I know we have non-lawyers who listen and watch our podcast, if you conveyed grants between 1986 and 1999, copyright transfers, assignments, you are in the window to try and reclaim those. For anything for 1986, you are quickly running out of time to do that under 17 USC Section 203. So talk to a legal professional to see if you're within the window to try and terminate those grants just for the US only, and talk about this whole work for hire concern that's been raised.
Yeah, that the work for hire concern is sort of, there's a couple of different facets to it. One is obviously if the writer was writing the screenplay under contract with a studio or production company as a work for hire, that's one thing. But lots of writers, especially writers who work in television or are working under those contracts, they have loan out companies that they use to
bad boys. Oh, sorry.
to collect their revenue and distribute, and handle some tax benefits and other things. The issue is when a screenwriter is writing a spec, but they do it under and through their loan out company, then it is still a work made for hire.
To the loan out.
Yeah. And for the loan out, and then not eligible for that treatment under, you said 203?
Yeah, and so we've got two cases to go look at. One is John Waite, and this dealt with sound recordings, but the court has ruled that John Waite, for anything that he created under his loan out that was then transferred to the record label, he can't terminate those grants. And then I know months ago we talked about pending litigation on the proposed termination screenplay issue on Bad Boys.
Wasn't there
and
also
that
Friday
one is still
13th?
pending as well.
I think
And I
the
think we
13th
talked
case too,
about. I think we talked about the Friday the 13th. So there's quite a few related to these loan outs that are not working the way the authors had hoped.
Yeah. Well, so that story was in our AI corner because of those allegations that the studio, Amazon in this case, and MGM, used AI to finish the film, even though there was a strike going on. I'm not sure that really has that much bearing on the copyright termination part of it, but anyway, so we're still in the AI corner. One more thing to talk about there is that, look, this latest filing against NVIDIA, there are now 18 different active lawsuits against the AI companies, and there's a blog called chatgptiseatingtheworld.com, and they have compiled a useful table to chart the status of all of these cases. And so we've got the link in the show notes. It's chatgptiseatingtheworld.com/2024 or whatever. Anyway, I've made a short link for it. So you can go to entertainmentlawupdate.com/AI cases, all one word, AI cases, and it'll take you to this table that has the status of all these cases, and I'm bookmarking it, and I'm just going to keep checking in on that because I think that's a great service. So thanks to the folks at ChatGPT is Eating the World.
Yeah, and I think that's great. And that, as I kind of peruse that, it's focusing on really what I would call intellectual property, content, AI cases. I feel like a year or so ago we talked about a different link, and maybe I can find that. About other AI cases, and it was, what I recall was, it was interesting that most of them were criminal cases where AI had been used. So our focus is obviously the IP, but it crosses over all genres of law, all areas to be aware of. So
something I think we're all paying attention. I'm actually going to be speaking at Podfest AI masterclass sessions. They're having a special course just on AI stuff in the podcasting space, and they've asked me to come and address some of the legal issues. So
And I talked to songwriters and musicians about it a couple of weeks ago.
course.
I mean, it's really, it's just interesting, and it's scary. It's scary for them as they feel like the machine is going to overtake.
Yeah. It's interesting. I've heard a lot of arguments about the creativity, and the human factor is always a thing, and somehow audiences will always intuit that there was a machine rather than a person behind it. And I don't know whether that's really true, but
I don't know.
anyway.
I'd never written a song before AI.
I've been
But I wrote one with AI.
Oh, right. Well, I've been advocating for some kind of a certification mark or some kind of a seal of approval that says, this episode or this song was entirely human generated, just as a way of sort of putting a brand on it. And hey, there's still humans involved.
Well, I don't think we can do entirely human generated,
Not
just
really.
because of the fact of plugins and all of the things that go into making music and sound recordings.
Good point.
Even if they're not, quote, AI. So
well, speaking of music, let's talk about this Nickelback case.
Out of Texas, out of the Fifth Circuit.
Well, that's your home turf, so you can take
it's my home turf. So Johnson v. Kroger is what I'm going with.
Okay.
Kroeger out of the Fifth Circuit. Just recent opinion. The Fifth Circuit Court of Appeals upheld a lower court's decision that the rock group Nickelback's Billboard topping 2000s hit, quote, Rockstar is not infringement of the Austin-based rock band Snowblind Revival's predating song, also entitled Rockstar, citing mere cliches. Johnston, who's the plaintiff in this case, sued in May of 2020, claiming that Nickelback's hit song had stolen substantial portions of his own song entitled Rockstar, including tempo. Don't think that's a factor. Okay. Song form, melodic structure, harmonic structure, and lyrical themes. I think that's an interesting way to couch that. He cited similar lyrics about the rock star lifestyle, making huge amounts of money and having famous friends. Well, that's me. Just right there. I live the rock star lifestyle. Anyway, in March 2023, U.S. District Judge Pittman decided that Johnston's case at times, quote, borders on the absurd. The judge wrote that any similarities between the two songs were, quote, outlandish stereotypes and images associated with being a huge, famous rock star, and they do not sound alike. So that made me go, okay, were there expert witnesses? Yes, both sides had expert witnesses. On appeal to a 3-judge panel, the court ruled Johnston's expert categorizes the lyrics into common themes, Johnston being the plaintiff, such as making lots of money, connections to famous people, and references to sports. But these are cliches of being a rock star, and are not unique to the rock genre. Singing about being a rock star is not limited to the plaintiff. Let's see, one lyric Johnston had was, might buy the Cowboys, and that's how I'll spend my Sundays. And Nickelback's was, and a bathroom I can play baseball in. Yeah. Similarities? These lyrics reference different sports. They reference sports. They don't even reference the same sports.
Right.
There was no copying, so that there was zero evidence that Nickelback had access or heard the plaintiff's song, which is a key aspect to it. There was claims that maybe UMG executives had access. But the court just said there was no direct evidence of copying. There was no access. There was no substantial or striking similarity, and just discounted Johnson's expert witness and said, this is not infringement. So,
it's always interesting when the judges are sort of, John likes to use the term bench slapping.
We love John. John keeps us rolling every month. So
John Janicek is our managing editor who helps us with stories and team and all that. And anyway, thank you, John, for that. There's another one coming up later on in the rundown that we'll share with you as well. That it was a big bench slap. Let's put it that way. But let us move on to our next story, which comes from a Billboard reporting on this. Earth, Wind, and Fire, the iconic R&B group, recently emerged with a victory in a trademark lawsuit against a tribute act that had used their name. Federal judge in Miami ruled overwhelmingly in favor of the original band, stating that the tribute group known as Earth, Wind, and Fire Legacy Reunion infringed on Earth, Wind, and Fire's intellectual property rights by using the band's property, including the well-known Phoenix logo, wordmark, Egyptian iconography, and even photos of the real members of Earth, Wind, and Fire, thereby misleading fans into thinking that the shows were for the actual Earth, Wind, and Fire. The lawsuit accused the Legacy Reunion of attempting to deceive consumers into believing that they were the authentic band, and the defendants allegedly hired musicians who had previously played with the real band, along with others who had never played with the band. They also falsely implied in advertising that this new group was the authentic Earth, Wind, and Fire, using the band's trademarks to boost their ticket sales. So the judge condemned the tribute band's marketing tactics as deceptive and misleading, and pointed to evidence like angry social media posts and emails from fans who had attended the shows under that false impression that they were seeing the real thing. Even though Maurice White, the founder of the group, had died in 2016, the original Earth, Wind, and Fire continues to tour with longtime members Philip Bailey, Ralph Johnson, and White's brother Verdine, operating under a license from Earth, Wind, and Fire IP, the company that is owned by Maurice White's sons. So tribute acts are legally permitted to cover specific bands' music, but they do have to indicate their status as a tribute band and avoid implying any affiliation with the original group. And the judge, Moreno, in this case, he said that the Legacy Reunion crossed the line. Using the term reunion and claims of former Earth, Wind, and Fire members' involvement, the judge emphasized the deceptive nature of all the marketing, regardless of the tribute band members' roles in the original group. Lots of complaints from fans who felt misled were cited in support of that ruling. And damages will be a separate trial coming up in May of this year. So, meanwhile, Legacy Reunion is prohibited from any further infringement of Earth, Wind, and Fire's trademarks. Yeah. So there we go. We'll be back when we know what the money amount is.
And I know in multiple states they have these tribute band statutes that limit how you can, or so many members of the band, and variety of things. But I mean, this really was intended to deceive consumers. We have, tribute bands that play around our area all the time. And I know last year at a very small little outdoor park venue, my husband was like, "Oh, look who's going to be there." And I'm like, they're not going to be playing there. Yeah. And come to find out, it wasn't the tribute act's fault at all. I think the event, the programmer,
the promoters,
either probably didn't actually know who they were. Well, and they just advertised it inappropriately. And I actually don't think it was anybody trying to fool anybody. It was just a mistake. And when we showed up, the singer-songwriters that were there were like, "Hey, sorry, we really did not want you to try and think we were this other group." Some ads went out.
Interesting.
Yeah, that they had nothing to do with. So.
Yeah. Well, it makes me wonder if shows like Beatlemania would still fly with that title nowadays. I mean, that's 40 years ago at least. But and what happens when the whole world knows that most of the original members of the band are dead? Does that change the analysis in these situations?
Yeah.
I mean, hard to say you were deceived if you knew that John and George have passed on and Paul's doing his own thing nowadays, right? So
and Ringo's got the all-star band or whatever it might be. So,
but I think there's something to take away from this is just looking, being deceitful is never going to work. It's never going to be smart. So
well, we hope not. And also, and this ties into the next story we're going to talk about, is make sure it's clear amongst the individuals or the band members who actually controls the band name, the trademarks, the logos, and what happens when people die or leave the band. Super important. So there were multiple trademark registrations for Earth, Wind, and Fire. And again, I think we talked about they were in an entity, this Earth, Wind, and Fire IP. Which our records say Maurice White's son owns. I haven't verified that. So, but takes us into Split Decision, which is a band name that actually went all the way up to the Trademark Trial and Appeals Board and part of the registration process. In 1990, Split Decision, also a cover band, but I don't think we know who they covered, was a 2-member part-time endeavor by Christian Zajac and Scott Kinka. Over time, it evolved into a 5-member full-time band performing at venues around the East Coast, clubs, casinos, corporate events. The band's name was chosen by the 2 founding members in 1990. 3 additional members joined the lineup. And then Billy Stott comes into the picture. He became involved with Split Decision to kind of manage the group. And he gradually, while the band initially performed about twice a month in small bars, it expanded its reach and its performances. And then Stott's involvement in the band's operation from 1991 until their separation in 2018 is what really triggered this dispute, because he claims, Stott, this is a new one for me, that, let's see, how does he word it? That he was the most active, non-active member of the band. What was his wording of how
non-performing member, I think is what he said.
Non-performing member of the band. And because he was a non-performing member of the band and did all these, quote, managerial roles, somehow that rose to him having some ownership in the trademark. Anyway, so Split Decision Music LLC files an application. And this LLC handled payments for performances and managed the business affairs. Stott and the band separated in 2018, initiated by an email by a band member. And Stott has not used the Split Decision mark since 2018. The band continued to perform under the same name, and the LLC filed an application to register the mark. So then we have the dispute. Stott opposes this application, and Stott claims prior ownership due to his management role, while the band argues for collective ownership based on their longstanding use of the mark. And so on appeal to the Trademark Trial and Appeals Board, the board reviewed actually Stott's claims from 2 different perspectives. I thought this was interesting. They looked at it as manager versus group and departing member versus remaining member, which is along the lines of what we talked about with Earth, Wind, and Fire. And they said, well, what are the functions of a manager? Does he act simply as an agent for the group? Does he do things like a producer in a theatrical company? Did he arrange studio time, schedule performances, responsible for decisions? And where the band members are not replaceable as actors in a play, and they existed and performed as a band long before the manager became affiliated with them. Then they looked at this departing member. Generally, there are 3 main factors to be considered in ownership disputes surrounding service marks as between a departing member and the remaining group. The party's objective intentions or expectations, who the public associates with the mark, and to whom the public looks to stand behind the quality of the goods and services offered. And the TTAB looked at the case of Bell versus Streetwise Records and said the band controls the name. And Scott failed to establish that he did control the band name. It existed before he was ever involved with the band. There was no assignment to him. And they said that just because he had a management agreement, that didn't alter the historical ownership. And his self-proclaimed title, here it is, as the primary non-performing member, was rejected. So I actually think the TTAB got this right. How did the manager He
Yeah, I
didn't
mean,
use the mark. That's use his ownership,
yeah,
his
they
right.
adopted the name before he came into the picture. They never sold it or transferred the ownership to him or to an entity other than the partnership of the two guys originally, I guess. Maybe the three new members also became partners, but I mean, we've all heard about scenarios where the manager is in for a band member share in the a
Yeah, and
band
maybe
share.
if he had been a member of the LLC, but it doesn't sound like he
Yeah,
was.
right. And I think they could have gotten to it just by saying, "Dude, you haven't used this mark in the last 5 years since you left the."
Right.
You don't have any claim of ownership anyway. You've abandoned your rights to the
Yeah.
title, but that doesn't seem to have been a part of this case. But I think they never assigned it to you. How can you possibly claim full ownership? And I think you said the band claimed that it was a shared ownership among all of the members, and so there may be still an issue of, well, was he entitled to some portion of it because of that? But we don't know
I
what the
say, yeah,
dissolution of the
I don't know. I
relationship.
mean, we often hear of, and I suspect it probably still
Yeah.
happens, where there are managers or record labels who
Mhm.
control the trademark of the
Sure.
band and they own those rights. Trust me, if you were to copy one of my documents where I'm representing an artist, we don't
Mm-hmm.
do that. And I don't do that in record label agreements either.
Yeah.
But yeah,
Well, I think there is a practice pointer here is that we do need to be mindful of the intellectual property that goes along with the group from its earliest days when there are changes in structure and the formation of an LLC or something like that. We need to transfer that IP into the company if that's the intention the parties have. Or in the case of Earth, Wind, and Fire, it looks like what was his name? White. He was the sort of sole owner of the branding there.
right.
So, we
And
need to
it's
ask the
yeah,
right questions.
and have those conversations.
Mm-hmm.
Those are the uncomfortable conversations to have over the years that I've
Yeah.
had with quote band members where really there's a front man and
Mm-hmm.
everybody else is along for the ride. Well,
Yeah.
should they all own it? You know,
And then
and
we get into the tricky questions of who's the client and do we have a conflict of interest when these
that's right.
issues come up. And yeah, it's representing the music industry, boy.
It's always so much fun.
Yeah.
So much fun.
Yeah. Well, let's move on and talk about this. Here we are. It's 2024. The pandemic, the COVID-19 pandemic began in 2020 and extended through most of 2021. And we're now starting to see the cases coming up that had to do with the force majeure clauses in contracts. And how did the pandemic operate
Yeah.
with those force majeure clauses? So we have a California case, a VFLA Event Co. LLC versus William Morris Endeavor Entertainment in the Los Angeles County Superior Court. Involves a music festival organizer, Event Co., suing Starry US Touring, Kali Uchis Touring, Big Girl Big Touring, and William Morris over the return of deposits they paid to secure performances by Ellie Goulding, Kali Uchis, and Lizzo at the VFLA Music Festival that they had scheduled in June of 2020. Well, along comes the pandemic and government restrictions, and they had to cancel the festival. So they demanded that William Morris return those deposits because William Morris was the agent for the artists. So they claimed that the force majeure provision they invoked it and claimed that they were entitled to the return of those deposits, but the artists refused the demand. And they say that VFLA bore the risk of cancellation due to the pandemic. And the trial court agreed with the artists, granted summary judgment, and now the California Court of Appeal for the Second Appellate District has affirmed that judgment. They held that the trial court properly granted summary judgment in favor of the artists and William Morris. The court interpreted the force majeure provision as not reasonably susceptible to VFLA's interpretation, and held that the artist's interpretation, the court also held the artist's interpretation did not work an invalid forfeiture or make the performance contracts unlawful. So I don't think we need to read the whole force majeure clause. But really what it came down to is the artists claiming that the right for the deposit is conditioned on them demonstrating that they were ready, willing, and able to perform, but for the occurrence of the force majeure. VFLA's argument was that it's ready, willing, and able to perform in spite of the occurrence of the
Yes.
force majeure. Very subtle differences in language. The judge said, no, the artist's interpretation is right, that otherwise it would make the force majeure provision indefinite and incapable of being carried into effect. And they would take out, take away the meaning of the sentence following it. So there you go. The judge said,
yeah,
artist's right.
I'm interested to talk to some promoters and venues and agents to see how they've revised language, because I suspect the promoter didn't think this is how this would come out, that if there was a force majeure that made it where they could not put on the event, then why would they have liability to the talent who didn't show up and perform?
Yeah, I mean, there is a sentence in that force majeure clause that we didn't read to you that I'm going to read now. It says, in the event of cancellation due to force majeure, then all parties will be fully excused, and there shall be no claim for damages, and subject to the terms set forth herein, producer shall return any deposit amounts. Producer shall, okay, so the producer is the artist in this case.
I think producer is the event producer.
Right.
Okay.
Well.
Oh, producer shall return any deposit amounts previously received.
Yeah, so I think that in this case, it's the promoter hiring the producer of the act. So
Got it.
The band, yeah. However, if the artist is otherwise ready, willing, and able to perform, purchaser will pay producer the full guarantee unless the cancellation is a result of the artist's death, illness, or injury, or that of its immediate family, in which case the producer shall return such applicable pro rata portion of the guarantee previously. So, yeah, I mean, this is not what I would call typical force majeure language, is it?
Right, because it really, to me, is saying the only way they're getting out of paying or getting back the partial payment is if the artist can't perform because of death, illness, or of a close loved one. That sounds like no matter what the force majeure event was.
Right.
If the artist was ready, willing, and able, the event planner, the event co, is out of luck. So anyway, I think folks who are in that part of the business need to read that closely. Or even any type of force majeure language. This needs to be read closely.
And, up until 2020, force majeure language was something at least most of the time, I think we glossed over it. Oh, yeah, there's a force majeure clause. Move on. And we didn't need to get
Sure. We have a natural disaster, of course. We're not going to show on.
Right. But actually, there are tornadoes and earthquakes and floods and things like that act as force majeure as well. But, typically, well, anyway, it is something we need to pay closer attention to. I think this case is evidence of that there was actually a dispute that arose because of the force majeure. So,
right.
Well, earlier I mentioned the bench slap reference, and this next case really, really it was a good example. So we talked about this, I think in a previous episode some time ago, maybe a year or so ago. It's the fight involving Travelin Livingston, the daughter of the songwriter Jay Livingston, who wrote the famous song Que Sera Sera and the song Silver Bells, the Christmas tune. Her daughter Tammy Livingston is suing her for declaratory relief, seeking to invalidate terminations that Travelin, the daughter, had otherwise anyway, she had submitted the termination notices regarding the song Que Sera Sera, and in doing so, apparently stopped the royalty payments that were going to the granddaughter.
Yes.
So
it's go ahead.
Tammy files this declaratory relief action seeking to invalidate those terminations or otherwise issue or an order stating that the termination doesn't affect her right to receive royalties. That complaint was met with a motion to dismiss. The court granted it, and we're now on to the second amended complaint. In a 19-page opinion regarding Tammy's complaint, the court basically said there was no reason those terminations should be invalidated, and there's no dispute regarding the obligations to pay. The judge, these are quotes now from the judge's opinion. First, the second amended verified complaint is a morass of argument and legalese. However, the parties' briefing doesn't do much to reveal the actual dispute. Another one. Each of Tammy's 5 arguments that Travelin lacks the authority to terminate the grants collapse under their own weight. Either they expressly contradict documents Tammy placed squarely before the court, or they are entirely unmoored from the law. Another one. Tammy fails to articulate or even gesture at how the relevant notice fails to satisfy the provision without reference to her prior duplicative arguments. In her brief, Tammy makes no attempt to explain why the que sera termination notice or companion termination notice do not reasonably identify the grants being terminated, instead electing to focus on notices relating to a different composition. And therefore, for the reasons previously stated, Tammy's not entitled to relief, and this remedy is not appropriate.
So what Jay Livingston did during his lifetime was he actually, I believe we advise many clients, or estate planning and financial planners advise many clients, is to set up perhaps transferring a trust and transferring your intellectual property, your copyrights, and your revenue streams into the trust. Well, what we are now finding out is that transfer is a contract to the contrary, and is an attempt to cut off the rights of the heirs listed in the Copyright Act to terminate these grants. This one, I don't know if this one was a 203 or a 304. So basically, the Livingston Trust was set up in a way in which the granddaughter was receiving a benefit from these copyrights. Her mother, who was the correct heir under the Copyright Act to file the termination notice, filed it and cut off the granddaughter. So
this sounds like a chapter in a bad reality show, doesn't it?
It does, but I look at it as a teaching moment.
Yeah,
is
absolutely.
To say, I just talked about this case 2 weeks ago at an estate planning conference.
Oh.
And I said, okay, I know all of you estate planning attorneys are going to come unglued when we talk about this. But if you have clients with copyrights, you need to come talk to me before you think the appropriate vehicle is putting them all into a trust during their lifetime, because it may not be. Or having them, if they're during their living, have them assign all their rights to an LLC as a loan out company. We talked about that one today too.
Yeah, well,
there may be reasons why we really need to weigh the cost of structuring the deals those ways. They need to be advised. And I think that's the issue we're having, is the estate planners and the corporate lawyers just aren't briefed to advise their clients of what the risks are in putting those structures into place. So.
And I wonder if anybody has figured out the right mechanism to avoid this scenario. Is it that the only way to effectuate the purposes of Grandpa's will, an estate plan, is to make it transfer by will?
In the will. It has to transfer in the will.
But then if you're setting up the trust for tax and other benefit reasons during your lifetime, does it have to dump to the estate, and then, on death, that trust liquidates, and then you get tax consequences?
And I don't know. And I think part of the reason we don't know the answer is those don't get litigated.
Yeah.
So it's like, if you put a pour over will in a trust, a pour over will into a trust, and those assets remain the assets of the individual author until their death, and then upon death they pour into the trust. I think that supersedes the termination, because the act says they can transfer by will.
Yeah. Well, maybe we have a listener who is really good at this.
And that's the conversations I'm having with estate planners, and the conversation I had with 2 estate planning attorneys last week was, well, if you think your clients are all your family members are going to always get along,
Here's an example.
Then let's
Mother,
do it this way. Because the bigger issue I see in the reality is it's a blended family.
yeah.
And so they've maybe always raised their spouse's children as their own
Mm-hmm.
children, but they're not their biological children.
Sure.
And they want all of the children to share equally. Well, their non biological, non adopted children do
Mm-hmm.
not have a right of termination. So
Yeah.
you got to plan for that.
Well, interesting stuff. If any of our listeners has insights on this, we would love to hear from you. Maybe even have you
Yeah.
come on the show as a guest to talk about these things. And best practices in these areas are still developing. I guess that's the answer. So,
Yeah.
well, we have talked a lot. Well, a lot. We've talked in some depth about the NFT, non-fungible tokens, over the last few years. I think we predicted it was going to be the big issue last year or something.
And it was a dud.
And it was but Congress has been paying attention to it as well. In 2021, there was a call from the Congress to study the issue of NFTs, and do the Copyright Office and the Trademark Office need to do something to address them. And after 2 years of study, there were a bunch of roundtables held in January of last year, 2023. That study is now complete, and it was released on March 12th. The offices, the Copyright Office and the Trademark Office, both submitted their joint study to Congress and concluded that current applications of NFT technology don't require changes to intellectual property law. Both offices determined that they don't need to make any changes in their registration and recordation practices, not necessary or advisable at this time. Sounds like it's sort of a let's take a wait and see approach, because we're not there yet. Partly because last year's dud status.
Well, and I think what we've figured out is that right now, as to the law we have in place, copyright law, trademark law, and a patchwork of right of publicity state law, it does cover the issues related to the intellectual property side. I don't know that, I don't believe the patent office was involved, or I don't know if the USPTO gave an opinion from both the patent perspective and the trademark perspective on that report. But what we have is going to work.
Right.
I mean, it can be applied. The existing law can be applied to the new facts.
It's working so far. We haven't seen any crazy outcomes or splits of authority that are, trouble enough that Congress needs to intervene at this stage. So let's leave it alone. Got bigger fish to fry. What those fish are, I don't know, but anyway.
I don't know. A more user-friendly process with copyright form, but maybe not.
Yep. Whoops, something weird going on with the screen here. Sorry.
We're bigger and smaller, but we almost made it to the end.
Anyway, that's for those who are watching on YouTube. By the way, we're on YouTube now, so
come check us out on YouTube, for better or worse.
Anyway, that does it for this episode of Entertainment Law Update. And as always, we want to say thank you to you, our loyal listeners, for spending your time with us, and to our sponsor, JD Supra, that leading platform in professional services content marketing that helps lawyers turn their expertise into networking and marketing opportunity, media visibility, and new business. Find out more about JD Supra by visiting resources.jdsupra.com. And of course, we welcome your feedback. If you have something you'd like to share with us, or that we've asked you for, like the information about the estate planning stuff, and we hope that you do, please leave it for us using the voice widget on our website at entertainmentlawupdate.com, or send us an email. The address is entertainmentlawupdate@gmail.com. Twitter handle, X handle is entlawupdate, ENTLAWUPDATE. And Tamara, how can folks find you directly?
Yeah, you can find me most social media at Tamara Bennett. That's also where I'm at on LinkedIn. That tends to be where I am more days on social media, if I'm there. So website tbennettlaw.com or createprotect.com. Either of those will get you to me. And Gordon, thank you so much for another great episode. And I know you are going to thank our crack team of volunteer contributors, but I also want to say thank you guys for making us, helping us put this all together, and I'll let you give the big shout out to him.
Yeah, well, I'm Gordon Firemark from Los Angeles, where you can find me. My website is firemark.com. Email address gfiremark@firemark.com. And gfiremark is the handle on most of the social media sites. So that's it. So, and yes, let's give a shout out to our team. We've got managing editor John Janicek and Charles Thorne and Mark Lindeman and Alexis Allen and Violet Zhang, all helping us out and making us look and sound good on these episodes. So we appreciate their help and loyalty and all these things. It's been wonderful working with you all, and we hope that continues. And if you are interested in joining our team, there's always room for more. You can reach out to us. Use that email address, entertainmentlawupdate@gmail.com. Send us a quick cover note and a little resume or something, and let us know that you want to be a part of it, and we'll figure out a way to get in touch and see if it's a good fit. And that is about it for this episode. We're going to say thanks again for listening, and until next time, that's showbiz.